Welcome to AT&T's teleconference service. Please. There are three participants on the call, including you. Joining your conference as the host.
Test. Yep, looks like it's going.
Good morning, everyone. It's November 8th, 2022, and this is the Law and Policy Committee meeting of the Fair Political Practices Commission. Ms. Linker, would you please take the roll?
Commissioner Baker.
Here.
Chair Matich.
Here. Proceed to item 1, public comment for items not on today's agenda. Do we have any public comment? Hearing and seeing none, we'll proceed to item 2, approval of the August 4th, 2022 committee minutes. Commissioner Baker, any edits or comments for the minutes?
No, I move to approve.
I will second. Is there any public comment on item 2? Hearing and seeing none, Ms. Linker.
Commissioner Baker.
Aye.
Chair Matich.
Aye.
The motion passes.
Proceed now to item 3, enforcement policy goals. This is something that I asked be placed on the agenda. I think throughout the time that I've been on the commission, there's been a discernible pattern of a reduction in the number of cases that we're resolving in what I believe to be a timely fashion, what I believe other commissioners have expressed repeatedly is a timely fashion. At the same time, I will acknowledge the complexity of the act just increases. The legislature frequently adopts new rules. I think we can point to the disclaimer rules as a good example that by their very nature can make it difficult to quickly resolve cases. And so we have also increased staff, though, in the enforcement division. And my understanding from the executive director is, as of today, we actually have more staff in the enforcement division than we've ever had. We also have implemented 2 tiers of a streamlined policy, with the goal being that we expedite what I call the low public harm type cases to free up more time for those complicated mainline stipulations. Unfortunately, we still are seeing what I would say is an unacceptable reduction in the amount of mainline cases coming to the commission. And by point of reference, I want to look back 2 years. In 2020, the commission was presented with 77 mainline cases. This year, including the 2 that are on the November agenda, we will hit 13 in 2022 in an election year. We need to do something different. We need to think more critically about ways that we can improve our transparency, improve our efficiency in the enforcement division. Folks work very hard. We have investigators that work very hard. We have attorneys that have been here for a very long time that are working really hard. And I will say this, when I was a very young attorney, I got a bit of advice from one of my mentors. And he said, Rich, deadlines are a lawyer's best friend. And at the time, I couldn't have disagreed more. I didn't understand it. And over time, I started to understand the benefit of that mindset when you have targeted deadlines. Sometimes you just have to make the best decision you can based on the information you have, and you have to trust your judgment. Things can't go on forever sometimes. And so with this enforcement policy goals that we are presenting, the hope is that by giving guidance that we expect there to be targeted deadlines at each stage of the enforcement process, that will give greater clarity of expectations for staff, and that the chief of enforcement, in collaboration with the most senior members of the division, would decide what the appropriate deadlines are to meet the policy objective of becoming more efficient in resolving our cases. So I want to just make sure that that's very clear at the outset. This is not the commission saying you have to complete a certain stage of the process in X number of days. I don't think that's appropriate for the commission to micromanage things at that level. What the commission should be doing, and what I hope the commission will do with this policy, is give a clear statement of our expectations that those deadlines exist, and give the enforcement division the ability to decide what the appropriate deadlines are. So I just wanted to state that at the outset. Commissioner Baker, I don't know if you have any additional comments.
Thank you, Mr. Chair. I appreciated that, and very much appreciate the reflection on your time as chair and both the feedback we receive from our own team as well as from commissioners on the issues of timeliness and just the workload. I'm coming up on 2 years myself, and in that 2 years, I've certainly seen a tremendous workload that we've had, and the many policy changes that we've advocated for. Some have come from us, some have come from the legislature, whether we're going to be there or not. And I think one of the most important things we can do to improve the efficiency and effectiveness of our enforcement team, and to have the parties who are involved in enforcement, the petitioners and the respondents and the public generally, is to have guideposts, have similar to what courts have, which is they have deadlines by which you have to respond. And internally, the courts, they have their own. If they start to have cases that they just get too bogged down, the judicial council and judicial organizations come in and say, hey, we've got to have guideposts by which you need to handle the workload. And I think this is one of the most important things we can do. For me, I see it as a way to also, not having received that same advice about deadlines, but lived it, to support our team. I've seen tremendous hard work. I've asked those questions during our enforcement reports that we receive from our chief, to know by when is a set of stages in an enforcement matter expected to be done, and have those guideposts in there. So I think it's one of the most important things we can do that will help our team be more effective with enforcement matters, and help the respondents feel there is a fair disposition and handling of their cases, the petitioners and respondents, and the public to have faith and confidence in the work that we do. So I fully support this effort. I am interested in hearing feedback from the team of folks who are presented with this. And then I'll have a couple of questions of my own that may be directed, probably not to you, but perhaps to Mr. Bainbridge or others in that process. But just want to say out the gate, I think this is one of the most important things we can do for this agency and the mission that we serve. And I am grateful to the team of investigators, both at the intake stage and all throughout, for the work that they do. They had to do during COVID, with the limited resources that are available to us. I don't see the legislature throwing a whole bunch more at us anytime soon, and I think we're working with what we've got. This will help and complement that effort. So thank you.
All right, thank you. Do you want to pose your questions, Mr. Bainbridge, now before we move to public comment?
I do. The question I have is, so this, as I see, is a suggestion that the commission adopt these policies. And if that's, as opposed to codifying it in regulation, and if that's the case, that the commission, the 5-member commission, adopts the policies and there were to be changes made to them, it's my understanding that, for example, if a new chair or a new set of commissioner comes along, no one chair or enforcement chief or someone else can just change the policies. It would have to be voted on by the commission at a public meeting. Is that correct? Because this is new for me to see us adopting a detailed policy like this.
Yeah, so the governance policy provides for the commission to be able to adopt policies to govern the operations of the commission. So whatever is adopted by formal action of the commission, in order to revise it, would need another action by the commission.
Okay. Thank you. That was important to understand, because I certainly know the chair is the only full-time member of the commission who, in many of these policies, is going to be a little bit more detailed part of the execution of it. Leads to my next question. At any time, can any commissioner inquire and know about what the status is of these policies? And I'm thinking, for example, I know that there's a statement that the workload manual or the system will be available to a commissioner upon request. But if a commissioner has questions about, how many of our cases are meeting the deadline in item B5, I certainly wouldn't imagine a commissioner asking about specific cases. But if a commissioner had questions about how well the execution is going, they are entitled to ask them and receive answers to them. It's not just the chair who would have that information.
Well, as drafted, the policy contemplates annual reports from the Chief of Enforcement. And that, by the way, is something that Chief Brereton already does for us.
Yes.
And so I think we would be on the natural receiving information on a yearly basis, perhaps even more frequently. And I think under our governance policy, if commissioners currently have questions about specific matters, they can always reach out to the executive director and she can route people to the appropriate person. I don't think anything in the policy changes that, but Mr. Bainbridge can correct me if I'm wrong.
Well, I do see the thank you. I do see the biannual reports, so I'm anticipating that there'll actually be one in June and January, which is a little bit different. But yes, it is if between now and then a commissioner wants to ask questions, I want to make sure it's clear that they're entitled to ask them, short of being about specific cases, I would think. And what would be any barriers to that if they're not?
I don't believe there is anything in this proposed policy on that particular question, so it would be the general policy and the governance policy that the chair was mentioning, where questions or requests for information would go through the executive director.
Okay. And I wouldn't encourage about specific cases, but if it's about how the policy's implementation is going and how the caseloads are going at different stages, those are the kind of questions that I'm thinking of, but they could be others, I suppose. I think that was my last one, because I know that item G says periodic reports by the chief to the chair and executive director on performance is to the chair. So the biannual reports is maybe where the commissioners, other than the chair, are most likely to get the updates. I'm thinking out loud at the moment. So thank you. Those are the ones that I have.
All right. Do we have any public comment on item 3?
Is it okay if I ask or make some comments, Galena? Thank you. So I've been in enforcement as an attorney for about 14 years. I've seen the number of cases rise up quite a bit from about 469 in February of 2015 when Gary Winnick stepped down. And then Galena took over and she rolled back some of the policies where Gary cut through red tape. And by the end of 2019, November 2019, the number of open cases rose from 469 to 1,727. And that was just a few months before COVID. And the one concern I have about the proposal you have is that I feel like it's more of the same type of red tape. And that the key to helping us do our jobs more efficiently is to cut through that red tape to allow Galena and Angela to cut through the red tape, maybe eliminate some layers of review to get stuff out, maybe a little bit quicker turnaround time on getting stuff back when it's being reviewed. That would be much appreciated. And I don't want to draw this out and make further comment, but that's the gist of what I wanted to say. Thank you.
Thank you. Appreciate it. And as a matter of logistics, this is being presented this month for the commission to deliberate on and take comment on. This is something that we would anticipate adopting if we're going to adopt it in January. And so to the extent that there are additional ideas, it's great that you suggest those. And I certainly hope that you will convey those to Chief Brereton and Executive Director West in the interim. To your point, which I think is a good one, and I should have probably mentioned this at the outset, I think it's a good observation that, depending on who is there at a particular time, their personal preferences as a manager can impact how things are done, right? And and by that I simply mean people have different styles. There's no one best style necessarily, but having objective systems in place it can in my experience, smooth out the different personalities that may exist in management at time to time if everybody knows what the basic expectations are going forward. So I appreciate that comment because I think it highlighted one of the benefits of having objective standards set forth ahead of time. So appreciate that. Do we have any additional public comment? Hearing and seeing none. Commissioner Baker, any additional comments?
Yeah, I do really want to invite suggestions, whether similar to what we received in that process. I know as a commissioner, and I think all the commissioners, if I could speak for them, would be very interested in knowing if there are areas that additionally might improve these goals I'd be very happy to hear from them, whether it's during public comment or if there are proposals that come to the enforcement chief that then could be presented to the commission. I wouldn't want them only to go to our executive director in chief and not hear about them. I would really welcome that from the folks who are on the ground and working on these cases. So thank you.
All right. If there's nothing further on item 3, we will now proceed to item 4.
Before we do, may I ask a question, Mr. Chair? And I'm getting used to our new system. I know there is written comments. I know that we don't read them, but I did want to take a moment. Because I'm getting new at this system where we see public comment. These get entered in the record or somehow. Good. I should know that. So I want to make sure they do. All right. Thank you. Appreciate it.
All right. Anything further before we move to item 4? All right. Let's go ahead and move to item 4. And we'll welcome to the table our senior FPPC Legislative Counsel, Ms. Nakano. This is our legislative development.
Good morning, Mr. Chair and Commissioner. Nice to see you both. So today we officially turn our attention to the next legislative year, starting with presentation of a number of legislative ideas. These ideas are presented to you now for discussion and feedback, and this committee may choose to recommend ideas to the full commission for potential sponsored bills. I'll start at the top of the list in today's legislative memo. The first idea is a reintroduction of SB 921 from this past year, which would create a centralized public record of campaign ads distributed on online platforms. The general purpose of the bill, as you'll remember, is to create more transparency about the campaign ads distributed online by, for example, allowing the public to view the campaign ads released by a particular committee across multiple platforms, and to view all online ads associated with a particular campaign or election. And if you'd like, I can stop between the ideas for discussion, or I can run through and we can have a discussion at the end.
I have no preference, whatever you prefer, but I'm sure I'll have questions.
Why don't you run through as if we have no questions, because we're good at interrupting you. So.
Sounds good. All right, the second idea relates to paid influencer posts about a candidate or measure. This issue came up during previous conversations on new regulations relating to the Act's disclaimer requirements, as presented previously by Commission Counsel Torrin Lewis. Currently, the disclaimer requirements do not cover situations where a candidate or committee pays a third-party social media influencer to post content about a candidate or measure. The Act covers content posted directly by the candidate or committee on social media, but does not extend to content posted by that third-party influencer and who is paid by a committee. This means that to the public, these kinds of posts appear to be coming directly from the third-party influencer and could appear to be exclusively their own speech, as opposed to the reality, which is that they have been paid to deliver a message. So this bill would require a disclaimer for the purpose of informing the public that the influencer was paid by a candidate or committee to post that content and deliver that message.
All right. Can I will interrupt you for just, I guess, a question / observation here. One, I think my observation is I think this is very important. This is a good example of we were limited to what we could do by regulation. So we need a statutory change to complete this process of, I think, improving transparency in this context. I guess the question I have for you is it, I assume it's true that we could, as a commission, when we're pursuing this proposal, if we do, set monetary thresholds so that we strike a good balance between improving transparency and not, if somebody got paid $1. I'm not sure that would be as meaningful to the commission as setting a normal threshold. So that's something that we would be able to do through the process, right?
Yes, I think in legislation we could provide appropriate limitations to the requirement.
Okay, I appreciate that.
Okay, I'll move on to number 3. This idea relates to creating transparency about who and what interests are attempting to influence the decisions of local redistricting commissions. The idea would expand the Act's definition of lobbying to include lobbying of these commissions. That's all I have on that one at this time. Any questions, comments?
It looks like there might be a natural break point since these are transparency related and we're going into another topic. So if the chair's thumbs up, I think I'll ask a question or two. On the first one about the online campaign ads, this is actually just for a refresher. The legislation last year went through many changes. Can you refresh my memory and the public who might be watching? Where did we last leave? What was the last format that the bill was in when it didn't? I think it didn't make it out of appropriations, if I remember correctly.
I think the main changes that the bill went through were relating to who had the reporting requirement. And so where we left off was requiring the platforms to transmit copies of the ad to the commission for that record keeping.
Okay, got it. And are we thinking, maybe this is just premature, that we may start from there again instead of going back to earlier drafts? Or you have any feedback on where you might propose starting with either Mr. Newman or others who are interested?
We're still in conversations with both Senator Newman's office and stakeholders and possible other supporters of the bill to see what they're interested in, what they're able to support. So at this point, I don't think we've made a decision about which we'll start with in the upcoming year, but it's in discussion.
Got it. So this is a more of a topic or proposal, and the actual language itself can be shaped all over again.
Yes.
So, okay. The item number 3 is a new one for us. There was legislation, if I remember correctly, could have been Senator Melendez or it was on the Senate side. And I don't recall if it was specific to just the state redistricting commission, but this mentions here local redistricting commissions. Is there an intent to not include state redistricting commission at all? Or why does it just say local?
I believe our legal division is developing guidance as to how that applies to state redistricting commissions, or how the current rules apply to those commissions. So I believe legislation's not needed, and I can be corrected if that's not true. But I think that the authority that we're lacking at the moment relates to the local commissions.
Okay, got it. And that's one that I'm very interested in seeing us work on. So I'm very encouraging, certainly on all 3 of these actually, but that one I think is going to be very responsive to the recent experience that so many communities had with redistricting that won't pop up again, potentially for another 10 years. So I'm encouraging us to be acting now as opposed to waiting to way off in the future again. So thank you for having this on the agenda.
Okay, seeing no further questions, I'll move on to number 4. This idea relates to the filing of reports and statements with the Secretary of State's office through the future version of their electronic campaign filing system. This potential legislation would streamline the filing process by allowing another individual designated by a candidate to file campaign statements on behalf of that candidate. As the memo notes, the candidate would retain ultimate responsibility and liability for their own statements. Number 5 also relates to campaign finance reporting. As we're able to look forward to the updated electronic filing system that will be adaptable to changes in reporting requirements, this presents a new opportunity to reevaluate the campaign finance filing schedule. Our current filing schedule was built over time in a more piecemeal fashion, sometimes constricted based on the limits of the existing electronic filing system. And so staff thinks we are approaching a period where it will be both possible and greatly beneficial to redesign our filing schedule in a very holistic way, based on best practices and taking advantage of the new technology that will become available. One potential new model would be to move to a monthly filing system with activity-based reporting only during some period before the election, such as 30 or 60 days. We imagine that this will be a multi-year project or a 2-year bill, and staff understands the need for robust input from stakeholders and other interested parties, which is why we imagine this will be a longer process. And also to be clear, these changes would not be made until sometime after the new CalAccess replacement system is certified.
Commissioner Baker, any questions or comments?
I think mostly a comment. It is on the file by proxy item. And I think I want to just underscore, this isn't to dilute the responsibility that a candidate or, controlling officer would have. And I appreciate the analogy that's also presented, which is kind of like your tax person is allowed to, gets your signature that says, I'm standing by these taxes, but they actually just have the administrative role of submitting the forms to the IRS. I think it's important that we're clear in that because, again, we don't want to dilute responsibility. We don't want to create an opportunity for a candidate to say, my treasurer was technically authorized to do this, but then they went off and did something before I saw the paper or that I didn't sign off on. So I would look for ways in which, this is my suggestion anyway, we're still incorporating, just like when you do authorize your CPA to file your taxes, you're still signing something, that attestation somewhere in the process that what is being filed has been approved by that candidate, even if the treasurer is the one who is doing the administrative role. So we don't create wiggle room that shouldn't be there. Thank you.
I agree. I think that's important. All right, Mr. Connor?
Thank you. Okay, moving on to number 6. This relates to updating privacy protections under the Political Reform Act. The Secretary of State is currently required to provide unredacted copies of certain statements when those statements are requested by members of the public, and these statements include bank account numbers. This legislation would allow the Secretary of State to redact bank account information when providing those statements. The Commission's legal division is also assessing whether there are any other areas in the PRA where privacy protections would be or could be similarly and appropriately updated, so other proposed changes may be forthcoming.
Any questions on that?
Okay. Number 7 would create a contributor certification requirement for purposes of educating contributors about relevant contribution requirements and prohibitions, including education for contributors who may unwittingly be participating in things like campaign money laundering. For example, the certification would state that the contributor is not using another person's name or a false name, and that the contributor would not be reimbursed for their contribution. This idea originated from a similar requirement in Los Angeles, and from my brief conversations with their ethics folks so far, they report generally positive experiences and a number of benefits to this requirement.
Commissioner Baker?
Thank you. And this is just I did not see the link that I could have checked on to read it. Are you able to provide just a top line examples of how they implement this? Is it, if it's an online contribution, it's one of the boxes that someone has to check, or is it do people even use remit envelopes anymore? I'm not sure. I would always carry one if I were a candidate, but how they are executing that. If you have any further details you can provide at this time, otherwise I'll do my homework before next week's commission meeting.
Procedurally, I'm not sure how they present that to contributors or what the process is. That is something I can check back in with them and get back to you at the commission meeting.
Thank you.
Any further? Okay. Okay, moving on to number 8. This would create a long-arm statute to add commission authority to exercise personal jurisdiction over out-of-state persons with materials or who are subject to the Act's requirements, in order to give the commission additional tools to obtain relevant documents and testimony of persons located outside the state.
Do you have a question on that?
Thank you. I actually just want to say, I think we've already given some feedback that there may be some natural partners in this one. It could be the District Attorneys Association. I know that when the chair and I visited with them at their annual conference back in September, this topic came up, and other ways in which we might be able to work together on legislation. And this one in particular, because kind of the previous agenda item we just talked about, I think if we are going to have some targeted deadlines, that hopefully we're also doing everything we can to enable our team to overcome some of the barriers that could be put before them in the course of investigation. This is one of them. We've talked about how many names are disclosed on a bank account and otherwise, but I think this would be an important one for us to push forward with allies who are out there and any others that might help us affect the things that are beyond our control otherwise. Deadlines are within our control. Guideposts and metrics we can control, but if we can help our team with statutes like or proposals like this, I'd like to invite that and look for those. Thank you.
Thank you. Moving on to number 10. This relates to, I think I skipped one, didn't I? Number 9. This relates to Section 1090. The Enforcement Division released a memo in January of this year at the Commission's request, which concluded that only the parties to the contract have standing to bring an action to declare a contract void that is in violation of Section 1090. This idea would add authority for the Commission to seek declaratory relief to void a contract that the Commission finds in violation of Section 1090.
And I just wanted to make sure, just to put a fine point on what you said. The Commission is not seeking the ability through our administrative enforcement process to void contracts.
Right.
Instead, we are seeking parallel authority with other authorized officials today to go to court and ask a judge to void the contract following a finding of a violation of 1090.
Correct.
Okay.
Thank you. Okay, moving on to number 10. This relates to the prohibition in the Act against certain mass mailings sent at the public expense that feature a candidate that will appear on the ballot. The Act prohibits these mailings during the 60 days before an election. Existing law only applies to tangible mailings, and this idea would extend the prohibition additionally to emails sent at the public expense.
Comments?
This might have been, this is one that we'll see where it goes. But with mail that it can be sent at the public expense, we have rules about that has to stop 60 days before an election. Email, some would say, is a big, glaring either loophole or example of how we can get finer with this rule. And one of the reasons is, I think when the mail rule was put forward, there probably was an email. I could be wrong, but I'm just guessing. And now it is pervasive. I can tell by the number of unread emails that are in my various email accounts. We need to be mindful as we're going through this that there are legitimate reasons for an officer, an official, to be sending emails 60 days prior to, and there are also you want to try to balance that out with you're using a state or government resource to promote yourself before an election. And it's going to be, I think, difficult to find where that line is, but I'm eager for us to engage in this conversation because it is a resource. Even if emails don't cost very much money, they are, that whole system of communication is a government resource that should not be used to promote someone 60 days before an election. So I think we'll have to roll up our sleeves on this one to see how to get that balance correct, and it may take multiple cycles to get there, but I'm glad we're starting to have that conversation.
Thank you. Moving on to number 11. This would allow the Commission's Statements of Economic Interest Unit to waive the late filing fee for good cause, such as if the filer was ill or hospitalized. Currently, the SEI unit has some discretion to waive the fee, but this discretion ends 30 days after the statement is due, after which they have no ability to waive the fee. If pursued, this idea would likely include more specific parameters as to what constitutes good cause. Number 12 would require electronic filing of statements of economic interest that are filed with the Commission for the purpose of modernizing the filing requirements under the Act. We saw some mandatory electronic filing requirements in a bill from this year, AB 975, which we may see reintroduced this coming year.
Can I, just for my own benefit, because I want to make sure I'm remembering correctly. So mandatory electronic filings of SEIs, I think that is a fantastic idea. We should absolutely pursue that. My question is, are we currently situated where we have a system that could accommodate accepting all of the SEIs being filed electronically and what would the cost be if we needed to build it out? I think we had this conversation before, but if you can remind me what about that?
To build up the system, to extend the system to what it was in AB 975, including only those listed entities, I believe the answer is that our system can accommodate that. Beyond that, there may need to be further expansions. Cost-wise, I'd have to pull up our analysis from that bill from last year, but we do have that that I can provide.
Okay. If we wanted to expand it to local filers, that's when we would have to do some upgrades to our existing system. But as it stands today, our existing system could accommodate this legislation.
Correct.
Okay.
I'll move on to our last idea, number 13. This would include various minor changes to the Act. The first that's listed relates to what counts toward the voluntary expenditure ceiling, and I'll start with a little bit of background on this one. The issue was discussed in the August 2022 memo by Senior Commission Counsel Erica Boyd. The memo included relevant legislative history. In short, in 2017, the legislature passed a bill that reorganized various provisions that were located within the definition of contribution by moving other terms and substantive reporting requirements out of that definition and into their own sections. According to the author's statement in the committee analysis, the purpose of the bill was to clarify and streamline the definition of contribution, and they stated that there was no intent to create new requirements or remove existing ones. Despite this intent, it appears that there was an inadvertent substantive change. Prior to the 2017 bill, the phrase campaign expenditures was defined to include 7 of the 8 activities listed under the definition of election-related activities. The activity that was specifically excluded was preparing campaign finance disclosure statements. The 2017 bill did not include that exclusion, thus broadening the definition of campaign expenditures for purposes of determining what counts against the voluntary expenditure limit. Again, the legislative history suggests that this was an inadvertent error. There was no intent to make substantive changes in this bill. Likely, it was simply a drafting error. So we would seek to correct this error in the cleanup bill. The second relates to limits on personal loans. The Supreme Court this year found limits on the repayment of candidate loans unconstitutional. The Act currently imposes a $100,000 limit on loans from the candidate to the candidates committee, and this change would strike that limit consistent with the recent decision. Third in this bill and last on this list, this idea would add further authority for a filing officer to waive the late reporting fee if the person successfully completes PREP, the Commission's political reform education program relating to that late filing. Again, because of that 30-day limit on discretion to waive the late fee, successful participants of PREP would still be liable for the fee even though they've completed the program. Staff thinks waiver here is appropriate and consistent with the goal of PREP to provide an alternative to any penalties. And as a last note, additional cleanup changes may be added to this bill if the Commission decides to move forward with it, including things like incorrect citations within the Act.
Great. Thank you, Ms. Takano. Commissioner Baker?
Thank you. When was the last time a cleanup bill was done? Is it something that we do every several years, or are we the ones who usually initiate it, or do the legislative committees do? I'm kind of curious on that.
The Assembly Elections Committee often will bring forth a cleanup bill. These tend to be very minor changes, things like incorrect citations or things that will be completely non-controversial. So they do that pretty frequently, sometimes every year if they find something. In terms of a bill that's brought by the Commission, or rather supported by the Commission, initiated by the Commission separately by a separate author, I don't know the last time that we've done it. I'm not sure what the history on that is for us.
When we amended the Act to make all the terms gender neutral, wasn't that part of a Commission initiated?
Right, yeah.
Back recently?
I think that's an appropriate characterization. That was just non-substantive changes that we wish to see.
Yeah, and I think what prompted me to ask was the item 2, little i's. That's a reflection of Supreme Court, United States Supreme Court So, but it is it seems it's a big substantive change, but it's uncontroversial in the sense that, it's decided by the highest court in the land. So it could qualify as a cleanup, I suppose. And made me kind of wonder how often these happen if there's, I guess it's ad hoc. It's not like it's on a 5-year schedule or 4-year or something like that. And it can be a pretty big change, but just one that is almost administrative given where the law is. So that's what I've learned in this process. Thank you.
All right, anything further for Ms. Nakano? Ms. Nakano, anything further on your end?
Nothing further for me.
All right, is there any public comment on item 4? Hearing and seeing none. Mr. Kano, I appreciate all of your effort in identifying these various legislative proposals for us. I would move that we recommend that our colleagues adopt this slate of proposed legislation later this month and direct Ms. Nakano to pursue those with the respective authors.
Agreed. Second.
Ms. Linker?
Commissioner Baker,
Aye.
Chair Matich.
Aye.
The motion passes.
Thank you. Thank you, Ms. Nakano. I'll see you later in the month.
Thank you.
All right, that brings us to our final item, discussion for items in January. Obviously, we will have the enforcement policy goals come back to us again in January. We should anticipate that with a target of commission adoption in January. And then Ms. Nakano's normal legislative report will be back before us in January. Any other items for January?
I did have one, and it was just to clarify on the enforcement policies. Will those go to the full commission in November, so that the full commission will be informed about that, and then January would be adoption?
Correct.
Okay.
The agenda for November includes
This item. Putting that out there.
And then we will come back in January with an eye towards adoption in January.
Got it. Thank you.
All right, so no other items for January. All right, do I have a motion to adjourn?
So moved.
Second, Ms. Lincoln.
Commissioner Baker,
Aye.
Chair Matich.
Aye.
The motion passes.
All right, thank you, everyone.
Thank you.